Namaskar. We are delighted to inform that Symbiosis Law School Noida, in association with Anand and Anand, has organized a webinar series titled Knowledge Series on Law, Intellect and Property in the month of October 2020. We have delivered 3 leaves, Leave 1, Leave 2 and Leave 3. Now we come to the last leave, Leave 4. The topics of the discussion today include understanding procedure in the original commercial IP matters, artificial intelligence on intellectual property, and tackling software piracy licensing and enforcement. We are delighted to inform that we have panelists who have considerable experience in the said field. To begin with, we have Mr. Shantanu Sahai, partner, Ms. Jayanegi, managing associate, Mr. Ashish Somasi, managing associate, and Mr. Siddhant Chamola, managing associate, Anand and Anand. Today's session would be moderated by Mr. Rohan Sharma, senior associate, Anand and Anand. Now I hand over the baton to Mr. Rohan. Over to you, Mr. Rohan.
Thank you, sir. Thank you so much. I would just like to reintroduce the panelists. We have Mr. Shantanu Sahai, who's a partner at Anand and Anand and heads the IT and e-commerce litigation practice. Then we have Ms. Jayanegi, who has an extensive experience in working in software matters. And then we have the duo of Mr. Siddhant Chamola and Ashish Somasi, who have been extensively involved in patent portfolios matters, while also having an avid interest in artificial intelligence and their application in intellectual property. So starting with Mr. Siddhant. Siddhant, can you just let us know what exactly is artificial intelligence?
Thank you for the question, Rohan. And before I proceed to answer it, I'd just like to reconvey our sincere gratitude to Symbiosis Law School and to everybody who's involved, Ashutosh from our firm, particularly Mr. Anand, who's made it possible for us to have this opportunity and to be speaking at this platform. Thank you very much. And without further ado, I'll proceed to answer your question. Well, I believe everybody is pretty much unanimously agreeable on what broadly artificial intelligence is. Basically speaking, it's a machine which has more than mechanical capabilities and exhibits some form of intelligence which resembles intelligent beings. Now, Rohan, if you could please put up the slides that I had shown to you, I think that would be a little more beneficial for our viewers. But in any case, well, there's a host of definitions available online, and all sorts of dictionaries go on to define artificial intelligence in a fairly specific but yet technical manner. There is one particular definition which I find to be of quite intriguing, and that's the one at the bottom of the last bullet point. It says a machine is intelligent to the extent that its actions can be expected to achieve its objectives. Now, this definition is coming from a book authored by Mr. Stuart Russell, who is an authority on artificial intelligence, and this book has made quite the headwaves called Human Compatible last year. I'd repeat that. A machine is intelligent to the extent that its actions can be expected to achieve its objectives. So a machine has a given objective, and it needs to act to meet that objective. How good does it act to meet that objective determines how intelligent or non-intelligent the machine is. So I hope with that broad canvas, we can proceed with that understanding of what artificial intelligence is and what form of artificial intelligence we are going to be discussing today.
All right, Siddhant, that seems to be the positives associated with the artificial intelligence. Can you also let us know about the risks that are involved in this?
Yes. So again, like I began the last time, well, everybody is unanimous that artificial intelligence is rather beneficial. There's no two ways about it. It's necessary, especially given the way that humans have progressed since the Industrial Revolution in the 1600s. Technology is now extremely, extremely inevitable to human growth. Having said that, and to quote Spider-Man, with great power comes great responsibility, and with great technological improvement comes a lot of risks. And if you do not mitigate those risks, then perhaps our progress towards development will take a U-turn for the worse. So the risks that I will be discussing, which are associated with AI, which are perhaps very prominent and everybody has already read about them or researched them in detail, are threefold. Number one, the risk of surveillance and control, which is basically an invasion of your privacy, and we don't know what's happening. We think we are giving limited control to a machine, but we already know our machines are listening to us at all points of time. There's someone else who's analyzing our actions and giving us targeted advertisements and whatnot, things that we didn't even ever contract for. Then there's obviously the aspect of fake news and deep fakes, which are being very, very prevalent today. We know the disastrous effects that things like this can cause. We've all read about the Cambridge Analytica scandal and how elections can be steered completely south of what was intended or what was actually happening, purely based on misinformation. Number two, which I guess everybody who's a sci-fi fan and has seen Terminator at least once knows that AI can't be spoken of without speaking of world domination and the possibility, or may not be the very realistic possibility, of us living around killer robots, in our midst and perhaps being subservient to them. And number three, which is perhaps very important and very real today, is that AI will be taking away a lot of our jobs. And what do we do once we don't have those jobs? Because we've been designed to a particular skill set, and how to mitigate these risks. So yes, with that, I'd like to elaborate on each of these three themes in a little more detail and how we can mitigate those risks. Rohan, if you could turn to the next slide, we can get straight to the issue of fake news.
Absolutely.
That's actually the next slide. Yes, thanks a lot. So as we were discussing, fake news is a big menace today. We all know that we all get these WhatsApp messages, and sometimes we can clearly detect that they're absolutely fake. We tell our parents or the elderly generation, don't listen to this. This is absolutely crap. But things have gotten very sophisticated, and now we don't really know whether something is authentic or something is absolutely perverted or manipulated. Well, there are two fundamental aspects of life which AI or no AI will remain. Number one, nobody wants to be lied to. Everybody wants to hear the truth. And number two, nobody wants to be branded a liar. So these two concepts are very fundamental to the entire debate on fake news, because so long as we're talking about fake news, we need to remember that the organizations, the media organizations who are spreading this message, true or untrue, are actually the real players. There are two parties at play here. Number one, the organization which is spreading the news, and number two, the recipient, which is us consumers or users or readers. How can we mitigate this problem? The problem already exists. Well, let's draw a parallel with something which all of us law students or legal practitioners or academicians know, the concept of a notary, where it started in England in, I believe, in the 1600s or the 1700s. Basically, a notary is a neutral party, and it has no interest in your case. You used to take a particular piece of evidence to the notary, and he would certify it as being true based on what he has seen. So that basically was the concept of going to a neutral party and having your information being certified as authentic. Actually, Rohan, I'm still on the previous slide, so if you could be there. If you take, now speaking about the notary concept, if you take that concept and you apply it to the digital world, we can have something called truth certification organizations. Work on this has already started, as you can see on the third bullet point there, the W3C Credible Web Group and the Credibility Coalition. Now, these are organizations which are intending to and have actually started doing a lot of work on getting information together, analyzing whether it is authentic or not, and then dishing out their analysis to other people. We all know how much people have started to rely on research analysis before we start forming our opinions, and we don't really buy anything which comes directly from a seller. So with this concept, I believe that this is a good steer towards the right direction of ensuring that there's transparency and there's truth which comes back in the game. Because, for instance, say we're all logged onto Facebook, and Facebook tomorrow gives us two options. Number one, it says, hey, you have the option of getting on your news feed items which are only certified to be true by these so and so organizations, or you have the option of seeing unverified content. When we're given that option, I'm sure all of us would opt for receiving only content which is certified to be true. I'm not talking about whether opinions are correct or not. I'm only speaking of the truth. And with that choice, I believe that a lot of these fake organizations and organizations which are purely thriving on propaganda and false propaganda for that matter will be pushed out of the door right at the threshold. Having said that, there's a certain amount of legislative reform also needed. What I spoke about is just a technological input. On the legislative front, I believe there's a lot, we all know there's a lot of discussion today, there's always been discussion on the freedom of expression, but there's not a lot of discussion on the right of an individual to receive true information. I believe some work towards that can certainly be done, and we should not always cling to the idea which democracies have been thriving onto, that in the end truth will prevail. But if in the end truth will prevail, what happens to all the trauma that people have to go sifting through whether this is true or whether this is not? Why can't we just cut to the chase? So I think some legislative reform on the right to receive true information must be addressed. And we can take a leaf from Germany's example, where it's introduced the Network Enforcement Act, which basically tells platforms that you will not publish hate speech and fake news. I mean, that legislation has come into criticism, but that's a step in the right direction. Now, Rohan, if you could turn to the next slide, I'd like to discuss this, what I believe is a rather fun topic of world domination. Well, all of us, I at least, used to think that there will one day come a time when there'll be an Arnold Schwarzenegger lookalike, or maybe some more menacing looking character, which will be the killer robot, and there'll be an army of those robots which will be out there to kill us all. But we all know that AI is actually progressing at another level. We don't have so many robots today as much as algorithms and codes which are actually running the entire world. Speaking of weapons, that it's not a distant daydream. In fact, weapons are already here, autonomous weapons, which are very, very dangerous. In fact, they're so dangerous that, as you can see on the screen, that autonomous weapons are being called the third revolution in warfare, third only to gunpowder, which we all know changed the game, and secondly, nuclear weapons. So that's the level of the threat that autonomous weapons, if left unchecked, of course, pose to the world. Strangely, these autonomous weapons are called laws, lethal autonomous weapon systems, which, as defined by the United Nations, locate, select, and eliminate human targets without human intervention. So we all know that we are in dangerous and uncharted territory. Now, if you could turn to the next slide, I'd like to give some pictorial depictions of what these laws, so to speak, are. If everybody can see on the left side of the screen is something on the one end of the spectrum. It's the Harop autonomous weapon system. It's been developed by in Israel, and it pretty much is a drone. The only difference is that it absolutely has nothing to do with human intervention. It can do a 6-hour sortie and can locate and eliminate any target that it has been fed into. On the right side of the screen is something completely on the other end of the spectrum, and something actually far more dangerous and invasive is the slaughter bot. As you can see, it can fit right in the palm of your hand. It has all sorts of codes which can help it to navigate and trace human activity and actually perhaps even eliminate them. So this can be doing it can be flying by your ear once every minute and you wouldn't even know it. So these are aspects which we are already dealing with. This world is already dealing with. This is not something in the distant future. So we need laws to actually help us mitigate the risks that people are faced with it. If
So,
Rohan,
Siddhant, just for clarity, this Harop seems to be an advanced version of a UAV that has been used by the United States Defense Forces in their different campaigns, which is usually controlled by a defense personnel. But as per my understanding, I understand that this is being completely controlled by an artificial intelligence algorithm.
yeah, your understanding is absolutely correct, Rohan, and that's where the danger comes in. As you said, that the US Air Force has actually done wonders in showing the efficacy of drones because they are where they're just not there's no human sitting in them, but there's someone controlling each movement of the drone with a joystick.
Precisely.
This Harop, on the other hand, completely depends on the code which has been fed into it. And therefore comes the problem of what if you feed the wrong code?
All right.
And where the next slide addresses the issue. So,
Absolutely.
as the topic of the slide is, or rather the first bullet point, not the topic, intelligent weapons, are they the real threat? Well, with the state of artificial intelligence as we have it today, no, they're not the real threat. The weapons themselves are not the real threat. What is the real threat is an incomplete or narrow-minded goal setting. Basically, in AI language, you give every AI bot a particular goal that it needs to achieve. And if you don't set it right, if you don't consider all the permutations and combinations which that goal, to achieve that goal, the AI may actually undertake, then you are cooking for yourself and for the rest of the world a recipe for disaster. As you can see on the screen, there's an expression which says, "I can't get you coffee if I'm dead." Now, this also is a very nice example that I took from the book Human Compatible, which I referred to in my first slide. Assume that you have a pet bot. It's a very cute little robot that you buy. You show it off to your friends and you say, "I can make it do anything that I want. And the first thing that I'm going to do is I'm going to have a burden off my back and I'm going to tell this AI robot to give me coffee by my bed at 6 a.m. every morning. I'm going to get up, I'm going to be completely fresh and well started for the day." That happens perfectly fine for all of us. After 7 days, perhaps you're not in the mood to get coffee at 6 a.m. Or maybe you don't want a bot to do all of your doings. And so you say, "Well, I'm kind of tired today, I want to change. So let me see if I can just switch off the bot for the day and I'll switch him on again." Something we all do, just plug the power off if I don't like something, right? Well, here's the problem. Uh, if you just fed in the input or the goal that the AI's, the bot's objective is only and solely to feed you coffee every day, then the moment you try to switch it off, it's going to perceive your action as counteracting its goal because it can't get you coffee if it's switched off. So it will take all means necessary in its thinking, if we can call it, to prevent you from switching it off. And therefore, you've invited or you have created for yourself a Frankenstein monster and not a pet coffee robot as you expected. So there again, so this was an example of what we were just discussing, you and I were discussing, of how improperly fed in goals can be a recipe for disaster. And that is something that is the real threat. So AI researchers and technicians in consultation with legislators and lawyers and academicians need to make laws which cater to these problems, and they need to make goals which are well thought out, so that there is absolutely we minimize the risk of any damage.
Sure, absolutely. So there has to be a difference between pragmatism and realism when it comes to AI.
Absolutely.
The code of instructions that has to be very comprehensive and very sophisticated in order to produce the result that you want.
Absolutely. And I think if we don't take those steps, then we're all on very sticky wickets.
Absolutely, as you explained. Sure.
now, I'll probably, I don't want to take up too much of my other co-panelists' time, so I'll just straight away jump to the next topic, which, as I said, is far more important today. Is AI taking away all our jobs? And what do we do if we're all jobless? I mean, I only have the skill set of a lawyer.
Absolutely.
Somebody says, whenever someone comes to our firm and says, "Oh, why don't you take this artificial intelligence system? It'll do all your research." I think, well, what am I going to do? 2 years later, am I going to be on the street? So I have that question, and everybody does at the back of their head. But ultimately, it boils down to this. This is not a problem which only AI has posed. This is a fundamental problem which human beings have been faced with. Like I said, since the Industrial Revolution, every new technology has replaced existing jobs, but it has also created new ones. And so, in this discussion of AI taking away our jobs, we always have to bear in mind that AI as it exists today will take away a certain subset of our jobs, maybe a very large subset, but it will also lead to better life management. Why? Because we can delegate all those things which we consider jobs to be actually degrading the human spirit or the art of life, as we call it. Now, there's an expression, like I was saying, we can't be these Luddites. There were people in the 19th century, the textile workers, who feared development in the textile mills and therefore started burning machines, burning mills down together. But in retrospect, we know that that was a foolish thing to do. Of course, it's not to disrespect anyone's sentiments, but with innovation in textile, we know the world only lived to see much better changes, and also people took up other jobs. So with AI taking away our jobs, yes, they will take away some jobs, but it will also leave room for us to focus not on physical labor so much, but on mental labor, which is actually the thing which separates human beings from the animal kingdom. So they say. So we say. So if you could turn to the next slide, Rohan. The next one, actually. Before this, actually, this was anyway. It doesn't matter.
There is some issue with that. I'm just trying to get on that.
It's absolutely fine. I'll just make my point very briefly.
Sure.
There are two kinds of jobs. There are two kind of categories. Oh, there we are. What kind of jobs should AI be taking away to make our life easier? Well, jobs which are physically intensive, say for instance, construction work, yes, give it to a machine. Of course, their laborers will face issues, but that is something which will eventually, in the longer run, make the world a better place. Human beings wouldn't have to be subject to harsh labor. Things which are routine or very clerical, such as punching numbers, ticketing systems, flight scheduling, this is already happening. And although jobs are being lost, but in the long run, it's making human experience far better. But there are certain kinds of jobs which, if AI ends up taking from us, it's going to lead to absolute disaster. And those are threefold primarily. Number one, jobs which essentially require human interaction. For instance, bank loan managers. If you have a machine which has zero empathy, zero IQ, and you go and make your case for a bank loan, and all it does is look at your financial record and say, "I don't see you making enough money in the next 20 years to be paying this bank loan." Well, you're dead. You're kind of gone. And the entire charm, or the trick lies in the charm, actually. So we're kind of taking it completely away, human interaction from an equation. So I don't think that, or not me personally, a lot of AI experts are not of the view that these kind of jobs should be given to AI devices. Second, and what is relevant in law, is where an action by an AI will have disastrous legal consequences. So, for instance, and I'm sure my colleague Ashish will be touching on these aspects in more detail. Things such as art production, music production. If a machine starts to produce music and copies music from one source and mashes it up with another source and comes up with what it calls an original version, well, you're in trouble, because we, being IP lawyers, we know that's trouble. And
Absolutely.
if to do that, well, then perhaps that's not the best or most well thought out strategy. And number three, and what is of fundamental importance, anything which requires governance of human beings, supervision of human beings, at this stage should not be given to artificial intelligence. So, of course, we can't have politicians who are robots. We can't have supervisors who's a machine. I mean, imagine that day. We all dread that day. And what if your human resources manager is a computer? We all hate. I personally dislike talking to a chatbot on Zomato. If my order for Domino's is late, I want to speak to a representative and say why,
Absolutely.
what's taking this time? And all I get
To
is a
get that
machine reply.
human feeling. Yeah.
Yeah, absolutely. So these kinds of things, I don't think that AI is, I wouldn't say progressive enough, but I don't think it is wholesome enough to to deal with these issues. Now, the next slide actually shows is a still from this movie called Elysium. For those who have seen this movie, it's a scene where Matt Damon is trying to make out a case to his parole officer, and look at who the parole officer is. It's a robot, and it has no EQ, has no empathy, and so therefore, it ultimately it tells Matt Damon that you've kind of not made your case, and I'm not going to give you your parole. So yeah, that's basically it. It's an example of the point that I was making, that these kind of jobs which require human interactions should not be given to artificial intelligence-led machines.
Absolutely, Siddhant. So, in real world, we have already seen the applications of AI. I mean, as explained by you, and we also know that there are special products like Alexa, Google Home, which are artificial intelligence, but on a very smaller scale. Now, I would like to present this question to Ashish. Ashish, do you see any future of AI in the legal fraternity? Do you see the courts or the judges using it to give more equitable decisions?
So, first of all, thank you, Symbiosis, and I'd like to express my gratitude to everyone present. And taking off from where Siddhant sort of left the question hanging and answering Rohan's question here, I think the most fundamental question, a more preliminary question here would be what constitutes the AI? I mean, what is it that exists behind the artificial intelligence? At the end of the day, it is the data that is fed into the artificial intelligence or the algorithm from which it can learn and give the results for the desired goal. Whether that desired goal is eliminating a human being using a killer bot or granting parole to an individual. At the end of the day, I think what boils down is a question of what kind of data is being fed into it. And this, I think, sort of gives rise to a multitude of questions. And that's where we see the courts and the laws developing around. So, for example, that I can start off with is the question of authorship. And that's something that Siddhant had touched upon.
A very important question. Absolutely.
Yes. So in 2016, there was a artificial intelligence algorithm which was designed to study the art of the painter Rembrandt. And it was asked to create a new piece of art. Something which baffled every artist was the fact that how lifelike the painting turned out to be. The question thereafter became who the artist is. Is it the person who has given all the data, which is Rembrandt, who has been dead for almost 135 years now? Or is it the algorithm or the creator of the algorithm or the person who has implemented it or purchased it? Or in which manner would you assign the authorship here? And so the question comes down to who owns the data and who is responsible for feeding the data or selecting the data which is fed into the algorithm. And from authorship falls a lot of legal prerogatives, which is where the question of liability, the question of bringing together how an individual is going to be held accountable for the final actions, and whether the data itself is a valid data set for a particular uh, you know piece in question. And this sort of brings us to the second area, which is AI and ethics. Traditionally, humans have always been biased people. Um, there have been issues of racial bias, there have been issues of gender bias. Even our laws currently have some form of bias, either positive or negative, which influence the outcome of any given, uh, you know, dispute resolution, so to speak. And so, Rohan, if you can just put up the slide on AI and ethics. This bias in the data set, which has crept in historically, is something which will affect every single court action that is going to come up. And that's where I think most of the legal work is going to take place and is actually taking place as we speak. So the first set, I think, where bias sort of creeps in is on, let's say, gender-based or authorship-based, or in the context of intellectual property, trademark-based issues. If any of you go onto a Google search engine, which is the most rudimentary form of artificial intelligence, which we interact on a daily basis with, and let's say you type in surf to buy your regular quota of washing powder. But somewhere in the background, based on your purchase history or based on preferences or even Google AdWords issues being discussed, the AI is going to tweak the results just so as to push one brand over the other and one search result over the other. And it sort of brings in the element of the bias of the collective. It may not be the individual's bias, which we are talking about here, but the bias of the collective is what is going to cause those search results to appear in the panel that they appear. And this is something which the lawmakers have to consider as the questions do come up before them. I think the foremost example would be the Google AdWords case. And the question of ethical bias in ethical and economic bias that stems from such a data set in a completely automated system which learns from multiple users and the collective itself is something which is going to be for the first time tested in Supreme Court, at least in India. The second sort of issue that example sort of which comes up based on this collective consciousness is liability in cases of autonomous vehicles. Let us for a moment put aside the authorship issue. And let's come to assigning liability and how do we assign liability? Supposing there's a completely automated Tesla car going down the road, and it has to choose between running over two kids who are on one side of the road, or killing a 80-year-old passenger in the car by colliding with the oncoming traffic.
Given a very unfortunate situation. Yes, absolutely.
Yes. But these are the questions which sort of will have to be answered by the judges.
Absolutely.
Like Siddhant had talked about and touched about how the EQ factor is extremely important and how AI should not take over jobs which involve a high level of EQ. I think it would, I mean, we would be remiss if we were to hope that that would be the case. The wheels of technological progress will continue and the boundaries would be pushed at every instance. And autonomous vehicles do pose a very realistic chance of such a thing happening. And so the social construct of how we would assign liability and how we would weigh one unfortunate situation vis-a-vis another unfortunate situation would come into picture, which typically is the role of a judge in a courtroom. And this something is what we will see as the days come by and as more and more of cases on autonomous vehicles and ethical choices between two very unfortunate situations will sort of creep up.
So Ashish, that is my next question for you. Like, how do you think is the landscape going to change if there is a practical application of AI in our courtrooms, in our legal system?
Yes. So this is where the third aspect of surveillance and data gathering and dispute resolution sort of comes up. Since most of the audiences, law students, they would have come across this judgment of the Bombay High Court, where I believe it was Justice Patel who had passed a dynamic injunction order granting rights to a private organization to actively take down torrent links which were cropping up, violating the rights of the producer of a movie. What's interesting to note is that most of these algorithms and most of these machine learning programs which are involved in the anti-piracy and takedown activities, whether court mandated or not, would be completely oblivious to the fair use provisions of copyright law or the privacy of individuals before taking down what it would consider as a pirated link or a torrent link which infringes the rights. It's a hammer which is used to solve a problem where what you actually require is a delicate knife in the hands of a surgeon to wean out each of these issues on a case-to-case basis. And I think this is something which Shantanu is currently dealing with in the Delhi High Court. And I think he can elaborate on it from here.
Rohan, with your permission, I may start.
Yes, sir, absolutely, please.
Now, the amount of information and data which we have received in last 45 minutes, I guess it is fundamentally impossible for us to process everything and try and streamline into a more specific and a practical aspect of implementation of AI and how a court would perceive it. Now, before I start, I have a slight disagreement in terms of when Siddhant mentioned that AI would take away our job, at least not so insofar as Siddhant himself is concerned. Him being a fantastic guitar player and having a great voice, so there's always the next job on the cards, at least for Siddhant. Not too sure about the rest of us. Now, in a way, when Ashish mentions about how the courts have perceived, these scriptures or the findings of an AI related, I think more in terms of the academics, I guess as a lawyer, we tend to evaluate what evidentiary value a particular AI related technology has produced in a way. And I may take an example of the software industry, so to say. Now, as all of you would understand that initially when softwares are being sold, they would rather be in a dongle format or would be available out of over the counters. One would try and deploy into their machine and try and replicate as an aspect of software piracy. Now, over these years, especially in last 5 to 6 years, what has happened is most of these softwares are being transferred online. And when I say transferring of a software, which also means that the registration to activate a particular software also happens over the internet. Now, we have seen over the last 5 to 6 years is fundamental increase in the rate of software piracy. Now, there was a recent study which was conducted by Regulators Technologies, an independent body in the US, which has ranked India at rank 5 in terms of global positioning of software pirates available in this country. Now, there was a report which was conducted by BSA IDC, which has suggested that approximately 60% of the total software deployment in the country as we speak today is having one or other form of software piracy issue. Now, what is the recourse which is available with these software programmers or owners, so on and so forth? Now, over this period, almost all software companies, if I may take name of Microsoft or Adobe's or even Dassault system softwares such as SolidWorks, so on and so forth. Now, they have deployed a technology which also uses AI tool, which is called a phone home technology. Now, typically what happens is once anybody tries to activate a particular software online, it simply collects the information which is very basic in nature, such as what is the software version which is being used. Now, what is the serial ID, what is the MAC ID which is being used to activate a particular software, which is the company domain at the end user side, so on and so forth. And apart from that, specific details regarding infringement, so to say. When was the first infringement activity which took place? How many number of infringements have taken place? So all these information are produced in a data form and presented before a possible infringer. Now, this is a marked shift from the way in which we as lawyers used to deal with software piracy issues earlier. Now, if you would understand, earlier what used to happen was we used to take the evidence, which largely would have been an intelligence which is gathered by a phone recording when an employee has admitted to use a particular software and the number of users, so on and so forth, and filed in the court of law.
Third-party investigation.
Absolutely. And those used to be the prima facie finding basis which the court would grant us the injunction. Now, apart from the injunction, the court would also grant us a local commission who would be, with the assistance of technical experts, would be allowed to visit the premises, search machines one by one, and make a deployment summary of the unlicensed software programs. Now, what this technology has done is it has reversed the entire process, wherein the entire details of infringement is actually available with the software publisher even before the filing of a lawsuit. Now, the total amount of time, energy, money idly would have been spent in terms of enforcement, it is already vanished. Now, all what we need to do right now is try and present this particular infringement report before a possible infringer. And I must tell one thing, that most of these software infringers are already some sort of a customer of these software publishers. They have one licenses, there's already a contractual relationship. All what is required is to present these papers and infringement reports before a possible infringer and try and negotiate a settlement. Now, as a matter of a hardcore escalation, what happens is a suit may be filed. But what we have realized is because of this particular technology itself, we have stopped filing lawsuits, the software publishers, and have tried to settle the maximum number of cases by either sending out a cease and desist letter or initiating a pre-litigation mediation in the High Court. Now, over the last year, as a law firm, we converted about 125 crores of software sales as a matter of successful settlements for our various software publishers only based on this technology. So just to answer your questions, yes, there are fundamental and practical use of the AI. Obviously we spoke about issues such as drones and other hardcore issues. But even at the moment when we speak, there are implementation at a very basic and a practical level where courts have recognized, courts have taken note of these evidences which is captured through technology and have passed orders basis them and have started making our lives very easy. Even as litigators and the lawyers, there are certain evidences which we collect, which is forensic evidence. Most of these evidences are being gathered using this technology of AI in a way. So therefore, to answer the question, the usage of this particular evidence from a most practical standpoint is already there. Delhi High Courts, Bombay High Court, even few district courts of Delhi, including Pune district courts, have been successfully, giving us orders based on this technology. And so to say, as we go along, obviously the spate of piracy is going to increase. It is going to be more complicated, but we are 100% sure that with the use of these technologies, we would be successfully dealing with these cases even at a court level.
Sir, so just wanted to understand one thing, sir. As you explained, this technology seems to be a security mechanism, which enables the software publishers to know as to where the infringement is happening and under what organization this infringement is happening. Can you please elaborate as to what are the applicable laws to it? And considering that this has come into the fore now, what are the defenses that the infringers in future can take against this particular technology? Let's say issues related to privacy as to how are you accessing my data and why are you accessing my data?
Yeah,
whether this is governed by a license agreement or anything, please.
Yeah, that's a very vital question, Rohan. Now, as you rightly said, there are contractual stipulations within the end user license agreement when a software publisher enters into an agreement with a subscriber. One of the clauses typically in almost all the software agreements would be that there would be some sort of a mechanism to detect any unlicensed usage by an end user. Now, be it Dassault Systems, be it Microsoft, all these end user license agreements have these stipulations. Now, let us come to an example wherein there is no agreement per se between a publisher and an infringer. Even in that case, there are laws and there are guidelines issued by, in fact, division bench of Delhi High Court, in a software piracy matter itself, wherein it has said that these cases of software piracy, which being by its nature a very complicated one, the evidence or the findings of an independent body or an investigator needs to be seriously looked into. Now, to test like this, what we did earlier was when we started initially filing lawsuits based on this technology, that we, apart from getting an injunction on the basis of the phone home technology data, we also took a court commissioner. Now, surprisingly and to our satisfaction, the finding of the court commissioner by doing an audit on the ground was bang on matching with the finding of the technology. And we did that in 5 to 6 initial cases. Now, time has come now that we don't even have to take a court commissioner, but these basic technology-based evidence are being accepted now as a matter of evidentiary value. Now, to answer your second question of what are the logical defenses, as you rightly said, issues of data privacy, hacking, so on and so forth are very logically being raised by the other side. Now, we have successfully managed to deal with them. Now, one of the arguments which we take is, look, this technology is something which is there only to detect piracy. It is not something which is trying to do a surveillance or trying to collect the data which is beyond the scope of the reason why the technology was deployed. Now, there is nothing, if you see, the technology captures which is even remotely coming within the ambit of sensitive personal information or some sort of issues which may be to the effect of hacking, so on and so forth. So, and even if these issues which are being raised at a preliminary level, these have been successfully mitigated by the orders of the courts itself, where the courts have actually come to acknowledge the fact that the purpose of this technology to be deployed is just to ensure that the piracy is being captured successfully all across, and not anything which the technology does is beyond the scope of its deployment, which means to carry out or to gather information which is, let's say, for example, what is the bank account of a particular individual, or what is the personal email of a particular individual, so on and so forth. So therefore, to answer your questions, these logical counter allegations have been successfully mitigated as we moved along. We've been carrying this exercise for almost 3.5 years now. We were having initial questions from the other side, but I think these have slowly started being mitigated.
Absolutely, sir. And also one more thing, sir, as you rightly pointed out, that during this whole pandemic, during the lockdown, there has been a substantial increase in the IP cases that have been filed before the courts. Now, as Siddhant had earlier explained, that AI is a double-edged sword. Considering that the high courts have been offering dynamic injunctions, what do you feel for instance, situations like domain name registrars, wherein they have been asked to ban or to prohibit certain domain name registrations using an artificial intelligence algorithm that initially prohibits any sort of registration to that. What do you think about these kind of injunctions that have been granted by these high courts?
I think there are arguments which are logical enough existing on the either side. Now, from a brand owner's perspective, they have a very valid case wherein each time they cannot go back to court saying, "Hey, look, I have again come across a domain name which is infringing," or every day there is some sort of a fraudulent website creeping up, and we cannot have a mechanism so far as the domain and registrars are concerned, not to screen them. However, the argument on the side of the domain and registrar is equally valid. Now, there are technologies available which, in few of the domain and registrar cases they have tried, especially in the US, but the technology in itself is not efficacious enough. All right. So, for example, if let's say a company like Amul or Flipkart, all right. Now, if we deploy a technology, most likely Flip would also be stopped, Cart would also be stopped. So, therefore, there are a lot of chances of getting false positives. So, the entire exercise eventually becomes a manual exercise. The moment it becomes a manual exercise, this sort of injunction, at least from the technology perspective, may not be efficacious enough. So therefore, what is required at this stage, if I may give my input, is that there should be court orders and there should be provisions within those interim orders wherein these dynamic injunctions may be systematically and efficaciously dealt with. For example, how about filing affidavits wherein there would be automatic extension of injunctions and takedown directions against domain and registrars? How about taking these cases before a joint registrars? Issues such as efficacious remedy provided under private mediations between counsels of both the parties. So there are options available. So my only submission at this stage is till such time these issues are not resolved fundamentally by a court of law, which at present there are different views coming out from different courts. Bombay has a different point of view. Delhi, as we know, has a different point of view. So therefore, I think the beauty would lie the way in which different courts would try and play, these orders on a case-to-case basis, rather than having some sort of a uniform, policy or a direction wherein these intermediaries are being held liable and being made to deploy technologies. Now, obviously, there are guidelines which are existing within the 2018 intermediary guidelines wherein these intermediaries are supposed to deploy intelligent tools to identify and take down, infringing contents, so on and so forth. There are certain, directions which have been issued by even Delhi court, wherein the domain and registrars are supposed to keep on taking down the request of not registering these domain names as and when the requests are made. But with the sheer deployment of technology, to what extent these are efficacious enough, that is something which needs to be looked into. My discussion with my clients were largely domain name owners and also, in fact, brand owners. They have somewhere come to realize that, by 100% or a blanket deployment of technology, it may not be a feasible format. And I'm not even looking into the intermediary argument in terms of public policy or a legal argument per se. But even from the technology standpoint, they may not be feasible, at least at this moment.
Absolutely, sir. Thank you for that detailed explanation. So, sir, as you rightly pointed out, that again, a lot of legal actions have been taken. I would like to present this question to Ms. Jaya. Ma'am, have you seen any sort of shift in the filing of these lawsuits and other legal actions during the pandemic?
Hi, Rohan. Thank you for the question. So what has happened during the pandemic situation is that, there have been rules in place for the Delhi High Court, but there were special practice directions that were issued by the Delhi High Court to supplement the rules already in place. And this was done by way of various court orders or notifications from time to time. So basically, the entire thing evolved in the last 5 to 6 months. So as you may recall that from 16th March onwards, the functioning of the court was restricted only to the matters which were related to life and limb. And rest of the matters, routine matters, yes, the dates were being given. And, gradually the court started, extending it to the rest of the matters as well. So then the nationwide lockdown was announced. This was done around 23rd of March. Now all the matters, for example, the urgent matters that were entertained only through video conferencing, and you could contact the registry through telephone. You had to mention it to the registrar that there was an urgency in a matter, and basis that the matter would get listed before the court. That further evolved where an e-filing link was published for mentioning of the urgent matters. So you can see the gradual change, over the last 5 to 6 months after the lockdown was announced, and during this pandemic situation, how courts have also gone beyond their usual practice to make, certain provisions and certain rules so that the matters could be taken up without causing any sort of hardship to the litigants. So what has happened is that there were some procedural and operational shifts as well. So for example, the limitation period to file your pleadings, to file your replies were suspended, because it was not possible to file your pleadings within the specified time. So
Absolutely.
this limitation period was done away with for certain period. Then what happened was that the notarized affidavits, which are required to be filed with your pleadings, your applications, that was also exempted to be filed. You could file a suit without filing the court fee. The court fee is the official fee that you file with the court. So what court did was that, that you could file the suits with the scanned copies, and even the physical signatures were not required. What was required was just the e-signatures, which, you could just sign your pleadings digitally, you could sign your plaints digitally, and you could file it through the portal. Another change that happened was the service to the defendants, because the pandemic situation was such that the court didn't want to create any hardships to the defendant or to pass any adverse order in such, in pandemic situation where people were already suffering. So what they did was that, they made service to the defendants mandatory initially, and proof of service was also made mandatory, which was done by way of affidavit. You need to file your, it could be done by way of email, it could be done by way of your SMS. So that was also another change, that was brought in. And physical service was something which was, which was not made mandatory during this time. And another thing that happened was that, the local commissioner. So what happened when in matters like these, so in matter like these, where the service was being given to the defendants, they could appear before the court and present their side of the case. But what about the matters, like, for example, counterfeit matters, where, you need to, your evidence, you need to preserve your evidence. So what in those cases, the court also realized that, certain hardship was being caused to the litigants. So the court, in certain cases where they thought that it was not possible to, where they appoint a local commissioner, it is not possible to pass an order. Sorry, can you hear me?
Yes, you are audible.
Can you hear me? Yeah, okay,
Yes,
sorry. So cases where local commissioners were appointed. So there were some execution challenges, So in these cases also, courts devised a new mechanism. So what they did was that it was not possible due to COVID to travel from one state to the other because of state restrictions and other restrictions. So they devised a new mechanism where they appointed a local lawyer or a local person. So for example, if the raid or the execution was to be conducted in Chandigarh, so instead of appointing someone from Delhi, the court appointed, for example, that person in Chandigarh who was local to that state or that region, so that that person did not have to deal with traveling from one state to the other. There were various hardships due to COVID pandemic. So that was another thing. And as you know, Rohan, that June is courts are shut for the summer break. So,
Absolutely.
so that,
Vacations.
yeah, so the court, yes. So the court also, made this month, the month, which is June, sorry, I'm so sorry. Yes. So it was made a working month. So these were basically the changes made during the COVID period. And there was also functioning of virtual courts, because of this online this thing. Yeah.
Absolutely, ma'am. So, having discussed everything, I feel like the most basic and the most important part that Siddhant would explain a little bit on would be as to what is the exact legal standing of an AI. What is the legal recognition that has been given to an AI? Siddhant, if you can just elaborate a little on that.
Thanks, Rohan. And thank you to all the other co-panelists who shed a lot of light on not only what, like Ashish spoke a lot about the law on AI and the gray areas, and Shantanu sir went on to discuss the practical applications and what's actually happening in court. And then Jaya ma'am also went on to discuss what exactly we've been doing the
The
last
absolute reality and the procedure. Absolutely.
absolute ground reality and how we're
Yeah.
grinding ourselves in the ground, if you can
Yeah.
say so. But to answer your question on what is the legal status of AI, well, of course, we all know there's no real answer to that set in stone at the moment. There are a few examples here and there. Uh, Rohan, I noticed that you've got the slides up. If you could just turn it up to slide number 14, which is legal status of AI. That I believe that will be a
Absolutely.
little to our viewers. But starting in any case, we've all heard about the example of Sophia, the robot who was given citizenship status by Saudi Arabia in 2017. Now, that really made a lot of headlines, but that kind of died down because at the end of the day, a lot of people started calling Sophia basically just a chatbot with a face. And what turns on it, okay, what happens when somebody gets official recognition? That's a gray area. We don't really know anything about that. But one thing is for sure that is something that we are steering towards in the future. Now, speaking of policy, the European Parliament Committee on Legal Affairs a few years ago has given this recommendation where they recommend that we must create legal status for robots which have a status of electronic persons and which can be held responsible for the damage that these robots are causing. As I touched upon,
Ajay,
sorry, I think somebody said something.
अरे इट वाज वेरी
Yes.
नाइस तो आजा बाद में बात करते हैं ठीक है
Shantanu sir, I think you're not on mute. I'm sorry, but thanks. Yes, uh, so the European Committee on on Affairs has given this recommendation that we must steer towards giving some sort of a legal recognition to AI, and the context of that recommendation was this that there's a lot of work that AI is actually doing. It's taking a lot of load off our backs, but every action has a consequence and a consequence in law. And what do we do about the actions which purely are automated and where there's no human intervention? So that is something that obviously Ashish has also touched upon in greater detail with that issues of authorship, what really happens, who is liable. For instance, if you were to take his self-driving car example, if we've heard reports of accidents being caused in the testing phases of self-driving cars. Sometimes they've damaged humans. On other occasions, they've actually damaged other robots also. So what happens? Do you hold the car responsible? Do you hold the company which is funding the research and project responsible? Do you hold the creator responsible? What really comes out of it? These are all gray areas. But having said that, as it is common ground that at some point of time or the other, we will start giving some sort of recognition to AI, if nothing else than to mitigate losses. and
a separate identity to AI.
correct, a separate identity to AI, only to, if nothing else, then only to hold them accountable for the damage that they
For the
cause
actions.
to other people,
Absolutely.
and not to praise them, because the praise, if any, should actually go to the people who are creating the technology, and not just the algorithm itself. But what happens if the creator of the technology did not intend for something to happen, but it's just the machine learning and the learning algorithms in the machine itself which completely went south of what was intended. So
Exactly. For instance, let's say AI starts learning the different emotions. Jealousy creeps into it, or humor, or anything else. What
right,
about that?
correct, absolutely. What if it starts to mimic our emotions and starts to well, that's actually a very interesting thing. And if I may just steer off course a little bit, there's imagine that you have human looking robots. Now that's something which is Sophia is one. There are more advanced robots, Jaja, and there's some other robots which look exactly like a human being. You can't tell the difference. And some people were saying, well, this is great because you can assign these robots the duty of childcare. So while parents are actually away because jobs are demanding, and the robots can look over the children. But have you considered, if not the legal, then the mental damage that it may cause? Because here's a
Yeah.
baby who looks at a robot which is very human looking, but isn't their parent, right? Who they think care for them as their real parents do, but doesn't care. So those things, if you start subjecting people without considering all, like I said, the whole spectrum of the ramifications, then it's something that we shouldn't put into practice. Coming back to the topic of what happens if you give legal recognition to AI, well, benefits are, yes, that you pin down some accountability and some responsibility, but there are problems also, because the way all laws operate is that if there is something wrong which is done, somebody will have to bear the brunt. Somebody will have, if some damage is caused to someone, well, you compensate someone. If you broke his car, give him the damages. That's basically that's what it is. But it's okay if you're doing it for even with a corporation, it's a legal and it's fiction that you create. But with an AI, what will happen? Will you start giving assets to robots so that when they
Precisely.
actually was damaged, you take away their assets? Okay, fine. If even if you do that, will it really care? Will it really care that its assets, number one, were given to it and now have been taken away? I don't think so, considering the fact that it's not a human being, and these aspects of emotion, of being possessive about your territory, are human emotions. Um, will What if you put a robot to jail? Will it care? Will it really make any difference? Because the entire prospect of this, the entire thought behind it is to reform also. If somebody does something wrong, you punish them and you teach them a lesson so that they don't do it again. But that is not going to that is an objective that just directly applying the same logic to artificial intelligence or robots is not going to serve. So these problems that everybody is already discussing, and there's a great amount of debate happening over it, and we will see some form of legislation coming in the near future. Having said that, let's talk a little bit, Rohan, about AI and some practical applications in intellectual property law, as we say.
Absolutely.
What I have at least touched upon is largely it's academic, if I may say so, and not academic in the sense that it's all theory. It's academic in the sense that it's not really practiced in our courtroom at the moment. Shantanu sir shed a great deal of light on what's really happening in courtrooms, what people, how are parties approaching it, how are courts approaching it. But we all know that that is something we're at a very, very nascent stage of these developments. Speaking of something which, though, however, is a field which is frequently litigated, and Shantanu sir also has addressed this in detail in practical terms, is the question of intermediary liability. These cases, since the Christian Louboutin judgment of the Delhi High Court, and actually since Shreya Singhal of the Supreme Court, have really picked up steam, and they are the talk of the town. whenever there's a new case on Section 79 intermediary liability, there's a lot of debate, discussion, because every decision is taking the law forward.
Mhm.
Now, one aspect where one thing is for sure that in an intermediary liability case, there's no hero and a villain. There's the brand owner which has a problem, and there's an intermediary who is not really objecting to the problem. It's saying, fine, I'll take it down. I'm fine with it. Because in any case, I have a hands-off approach. My entire business model is not to really promote something or not to demote something. I'm just a platform, which is the intent of the law as well. But one thing that we are seeing in court every now and then is that brand owners come and say, look, with each infringing URL, I can't keep coming to you or going to court with each and every link, because these links are spreading by the hundreds of thousands by minute. And
They're
Shantanu sir
like
touched.
Hydra-headed links. You cut down one and there are seven other popping up. Yeah.
Absolutely, absolutely. And that becomes a problem for brand owners. I mean, it's not good legal strategy also, although it's effective to go to court, get an order, but then there's a lot of time and investment and of resources which goes into it. And that's something that really brand owners wish to avoid, as well as intermediaries who don't want to be defending actions in court only to say, I'll take it down. So what is an approach? Well, academically speaking, and theoretically, if you were to discuss this, artificial intelligence can play some role. Why? Because case law, in not only in India but actually as upheld by the CJEU, has said that once infringement has been established, then in certain cases, not in all, in certain cases, an intermediary can be required to take down similar acts of infringement, not just that particular URL which is complained of, but similar instances of infringement. That one recent case was from last year was the Facebook Eva case. And similarly, the German federal court has also gone on to say in a copyright infringement matter that if it is proven that the entire platform was designed to promote copyright infringement, then it will be the responsibility of the platform to conduct routine checks to ensure that its platform does not contain infringing content. Now, this is brand owners is great for right owners, but it poses a practical problem for an intermediary. For instance, it may not have the wherewithal to really conduct routine checks. It's, as I said, and as we all agree, it's not its business model. It's only runs a platform. So it may have to employ a lot of resources to actually keep looking into these hundreds and thousands of links, and there's a lot of scope for error. There was this case which I just spoke about, this German federal court in 2013, which was the rapid share case, which said that, okay, here's something that you can consider, and it just threw off this recommendation that you can even employ search engine optimization techniques. You can resort to Google. You can even employ web crawlers to do your routine checks for you. And if we were to take this analogy forward, if and when artificial intelligence becomes that reliable and cheap and accessible for all platforms, whatever their size, then this is a technology which in theory and in concept can be applied so that the job of the intermediaries doesn't become too onerous for them as well, and human intervention can always be required wherever it's necessary.
So for reference, if I'm not wrong, as I remember, I think RapidShare was a link shortening site wherein you can upload several files, just like MediaFire and other torrent websites, and you could make it available to all the public and anywhere around the world. You could download any file you wanted.
Correct.
All
And it was found that the platform itself was such that it was promoting copyright infringement. So now that's, yes, on the
Precisely.
fact, there's today we see a lot more bona fide and true neutral intermediaries. But in any case, I was speaking more on the conceptual aspect.
Understood, Siddhant. Oh, okay, so we have one question from Mr. Abhigyan Thakur. Abhigyan, I'll just unmute you and you can just ask the question once. Hi, Abhigyan, can you hear us? Hello?
Yes, sir.
Yeah, Abhigyan, please.
So do I need to turn on my camera also?
Absolutely, if you, it's your choice. whatever feels comfortable.
So I just have a small question. Like, so Siddhant was just talking about the artificial intelligence and how we can, cannot punish the AI, right? So I definitely understand, like, in the meanwhile, whenever we say about the AI, the creator of the program cannot be punished. If that is a complex program and the program is created, or the new program whatever is created, and the AI already take its position in what to do, in that position definitely the creator cannot be punished. But can we not punish the AI?
Siddhant, the
Thanks
question, yeah, please.
for the question. Can I answer it? Sorry, Rohan. I think I cut you short.
Absolutely, Siddhant, please.
Yeah, thank you for the question. I certainly think that, like we discussed, it's not a question of whether the AI can be punished or not. The real, it can be punished. Uh, you can create a legal entity out of it, and then you can say, well, all your assets are gone away, or you're put in some sort of a virtual jail or some sort of a thing. But the question still remains: does the AI really learn anything from that? Of course, now there can be a counter argument that, well, if AI develops strong enough and it has strong learning algorithms, and if it is perceiving everything from human beings, then it can also learn. And but we are not at that stage where it can mimic human emotions, or to such an extent that punishment really leads to lesson and then reform. I hope that answered the question.
Abhigan, is there anything else
Yes, sir.
that you would like to get clarified?
Yes. Yes, sir. Yes, sir. So actually, can we not just go for a very basic algorithm which can create or give a sense to the AI that it is pain, right? Nothing more but the emotion of pain in the form that if we, what AI is made of, it is made of algorithm. So if we actually delete or remove algorithm of the part, and we just give it in the form that it can just relate it to the pain, that if whatever it has learned, we are gonna delete it if it is gonna do something which is by some laws or some anything whatever we create, we are just gonna give it a algorithm or make a algorithm which can just give it pain.
Well, number one, I hope I've not given the wrong impression. I'm only a lawyer with an interest in AI, so I'm not very capable to answer really technical aspects of whether you can give them a pain and what's the consequence of that. Having said that, there is quite enough of literature both sides. Uh, and we've discussed this, that you can code a particular machine, or you can create an algorithm to feel a certain way or to react a certain way. But then again comes the problem, is that how are you coding it? For instance, if and we've addressed this earlier, if you've given it a very loose, or I wouldn't say loose, but not a very wholly holistically thought out objective, then the introduction of pain and feeling pain and therefore learning from it may also run counter to its objective. Correct? For instance, if we go back to the coffee example, if my bot is only designed to get me coffee, and I'm trying to induce some pain to it because, say, it spilled my coffee on the way to my room, and I say, no, bad machine, and therefore you should learn from your mistakes. But it's like, what if you are telling me to be bad and inflicting me with pain, then this may somehow go counter to my only objective of getting you coffee. How well I get you coffee, whether I'm supposed to learn anything from this, may run counterproductive, and this may not learn in that process because it may see whatever you're trying to do as being counterproductive to its sole goal. So yes, you can certainly code algorithms in a way that they actually what is called reinforcement learning, that they learn from the environment and they improve. But then that is a field of benign and benevolent AI, and that's the topic for another discussion. There is certainly a lot of discussion on it, but I think that this forum is not going to address it. Also, we're short of time.
I
Sorry
understand.
about that.
Thank you so much.
Okay, we have Miss Charvi also. Miss Charvi, I'm just unmuting you. You can just present your question. Chavi, I'm unable to unmute you.
Oh,
Just a
I
second.
think I
Yeah,
managed I'm unmuted
sure.
now. All right. Thank
Please,
you so much,
please go
sir.
ahead.
And sir, my question was, this has been a very interesting, I think, field. And what really caught my attention was that you said that AI and algorithms could be used to, discover different and similar sites or links where copyright infringements are taking place. Do you think then, hypothetically, that we might even be at the point where Facebook could
Mm-hmm.
employ such algorithms to prevent, for example, the spread of misinformation or hate speech, because it was largely credited with the Rohingya genocide, because it had like one translator and they couldn't really filter through all of the misinformation and hatred and hate speech against the Muslims in Burma. And it's happening again, of course, as the Burmese elections come up. So, do you think that this could then have some sort of effect on democracy worldwide as well, if we could then enforce some sorts of standards on these apparently very neutral and amoral companies?
Ashish and Shantanu, sir, would you like to answer this?
Yeah,
Sure. Shantanu, go ahead.
yeah. So I'll try and answer that, Javi. See, thing is, uh, the way we perceive AI is an element of technology. Technology is created by humans for the benefits of humans. Now, just as an example which you have quoted, you know, hate speeches, what amounts to defamation, what amounts to breach of privacy, so on and so forth. Now, it differs from region to region. Let's say, for example, a defamation, so to say, in India may not be a defamation, rather may be a free speech in France. So, to what extent AI has been attuned to imbibe all these aspects of human emotions, of other angles of the characteristics which constitute a human being, and therefore would give a result that this particular element needs to be forbidden, needs to be taken down or not. So just to answer your question, right now, as Siddhant also rightly said, the reason why a particular technology from an evidentiary perspective would be attuned to create some sort of a value in a court system or not, that largely depends upon how the technology is created. And not only once you create the technology, how you use the technology, and it's an evolving process, if I may say so. Today, it may not amount to defamation, tomorrow, it may amount to. There are certain domestic laws which will basically grant a particular angle or aspect to it, which will again qualify that to be a violative in nature. So, therefore, any violation in France may not be a violation in India, vice versa. So, one obviously will have to see as we go along how this technology takes up and how it shapes up, and obviously with the efforts of the court system and with the legal attributes, lawyers involvement, we will then figure out how do we create certain thing, probably create some sort of an evidence which would basically help us tomorrow once we try and go along with this.
Yeah, Ashish, please.
Yeah. So I think that basically answers the question. And this is a question which has been sort of addressed by the courts repeatedly over the time when it passes either a dynamic injunction or a takedown order with broad consequences in order to address, like you guys put it, a high-headed problem. And with the advent of internet, mass communication has, arrived at a place where you can hide behind, anonymous screens and work the public forums like Facebook and WhatsApp to use it to your advantage. So there is no answer. AI is a possible answer, but to what extent will AI actually work is something which will depend largely upon how the AI learns and what the AI learns. Because at the end of the day, machine learning and artificial intelligence is something which observes human behavior, observes the biases and the faults which lie in our own behavior, in the way we sort of democratize or in other places, monopolize the streams of communication and the topics of communication. So yes, what the AI learns from is the human behavior, and when it mimics human behavior and renders its own judgment on whether something is defamatory, whether something is not allowed under the freedom of speech, and even if limited to a geographical area, is something which has to be considered within the larger social context. And these parameters are where frameworks, national frameworks, have to be developed not only by the governments but also by the judges who, over the years, have been the sole arbitrators of deciding what is permissible and what is not permissible.
I hope that clarifies your query, Chavi. Is there anything else
It
that you would
does,
like to know?
sir. It does. Thank you so much. The answers were very insightful.
Next, we have Miss Lisa Sankrit. Lisa, if you could just present your question, and to the if you could just let us know the speaker that you want to have the question answered from.
Good evening, dear panelists. So, sir, my question is directed to Siddhant, sir.
Yeah.
Sir, we know that it is the creator who puts in the algorithms in the AI. So, for instance, if I am biased, I am a right winger. Just for instance, I am a right winger. I would just put in the data which I would want to propagate. So, how would that, like racism or all these doubts would be cleared? Because AI would then be biased. Whatever if I create a robot, so that would be biased. So how do we deal with that?
Thank you for the question. I think Ashish has taken the biased which is inherent in AI as a result of this improper coding. He's already elaborated on it. But if I may attempt to answer your question, number one, like I said, it should never be. We should not progress in our law to a situation where we are only punishing the AI, right? So your hypothetical assumes or proceeds on the basis that it was the creator who is actually biased, is the creator who is actually the mischievous fellow here, and he is just using technology to perhaps magnify the impact that him as being just one human being can do. So in situations like this, number one, where we already know that it's the creator who's doing this. Number two, there are significant already developments or discussions on what to do with inherent AI bias and how we can neutralize it. And number three, once we know that it's the creator who's actually at fault, we just punish the creator and not the AI. I mean, this
Thank
is
you so
pretty.
much, sir.
It may sound a little. I'm just saying that the hypothetical is pretty straightforward. Of course, AI bias is a huge topic, and that needs to be delved into detail. But this hypothetical, I believe it's just blame the creator.
I mean, to summarize it and to kind of give it another understanding, is that the creator also comes from the local demograph, and whatever biases are there prevalent in that, obviously those will get transferred to the AI, because end of the day, that is the creator. Next, we have Miss Ayushi Sahni. Ayushi, if you could just present your question, please.
Am I audible?
Yes, you are.
Good evening, everyone. First of all, I would like to thank each and every panelist for sharing such interesting and important information. And also would like to thank Ravande sir for giving us this opportunity to attend this seminar. My question is directed to Ashish sir. So, sir, the question is that should the intellectual property law allow that the AI technology be declared as the inventor of a patent application? Or should it mandate that only human beings could be inventors to avoid ambiguity in the invention's ownership? So, should there be any legislation which determines the human intervention, or should the AI be straight away declared as the inventor?
You've posed a very interesting question. There was an article which was quite recently published, which showed how in the last 5 years or so, there have been over 50 inventions which have been filed before the USPTO with significant AI components involved, be it something like a software used for removing content from a photograph, or virtual reality, or superimposing images or image recognition technologies. Any number of these technologies which have sort of over a period of time learned and developed based on the information provided to them by their inventors, the human inventors, have been credited to the human inventor itself. But what we see progressing downstream is a larger focus on the data itself. And this is where the international focus on protecting data is sort of taking shape, which will sort of define the conversation around ownership of AI. Because at the end of the day, what an AI learns is from the data that it's provided with. So who owns the data might just actually answer your question as to who created the artificial intelligence being as a person. That's one of the directions in which the conversation around AI is moving. Of course, this is something which will take the shape of a much larger issue of what if the data belonged to a person who is long dead, like in the case of the Rembrandt painting or Schubert's music? Then who becomes the owner? Where does all of that data in the public domain that the AI has learned from go to? Whether an individual legal personality has to be assigned ownership, and therefore in effect, the patent ownership as well. So yes, it's an evolving question, but the answer may lie in the teaching format and the teaching modules and the ownership thereof.
If I may just add, thank you, Ashish.
Absolutely, please.
Ashish is absolutely correct that it largely depends. It will largely depend as and when the law progresses on what really is the sum and substance of the data which is in question. As of now, if we were to speak and if we were to answer that question based on the law as it exists today in different jurisdictions, there are recent decisions, in fact, which answer this very question on whether an artificial intelligence software or algorithm, even if it comes up with an invention, can it claim a patent over it? And the straightforward answer to that at the moment is no, because the US PTO and the UK IPO have both said that the requirement for an inventor is that he must be an actual individual, and by individual they went on to interpret it as being a human being. If you were to interpret it in accordance with our Patents Act, we don't really, I don't recall a definition of who is an inventor is corresponding to that, but I believe a patentee has been defined as so on and so forth, but a person, and unless, like we have discussed, courts have the power to confer the right of a person in law on certain non-existing things like the Ganges River or the idols. But for the time being, there is no law in India and none known to me outside which say that a person or an inventor is actually an artificial intelligent software.
Thank you for that clarification, Siddhant. Considering that we have overshot the time limit a little bit, I would just request if there are any questions in relation to the software piracy angle or about the functioning of the courts, as we have already elaborated quite a lot on AI. I would request the other speaker, Nayan, if you have some questions regarding the other two topics, please go ahead.
Good morning, sir. Sir, I had a question regarding AI and IPR only, if I'm
Please
allowed.
go ahead. Please go ahead. Let it
Yeah.
done. Yeah.
So as we discussed that AI cannot be allotted a patent. So I wanted to ask whether the intellectual property rights of a creation by an AI or machine learning program would be accorded to the developer and programmer who made the artificial intelligence, or to the user to whom it may be licensed by them and who fed the data to AI, which led to the produce of the creation. Also, can we apply the work product doctrine here and awards the rights to the user?
Rohan, who's that question directed to?
Sir, it's directed to Ashish, sir.
Hello, am I audible? I think I have disconnected from the call. So if Ashish, you could just take
Yeah.
forward this.
So yes, I mean, all of these are possibilities that it could be the user who is granted, but typically under the current legal system, it is the author of the software program, the creator of the algorithm, so to speak, who would have the copyright in the final product. Somewhere down the line, if the licensing agreement that he has with the user allows the user to enjoy certain rights over the derivative work that comes out of the software. For example, if you have Microsoft Word and you use Microsoft Word as a licensee, and you type out your article or you type out a code and make something out of it, you obviously will have the rights over the derivative work and the work product that has come out of using the original software which you used as a tool. There, of course, how much of the original tool that you have used, whether that amounts to patent infringement, whether it's permitted under the license agreement that you have with the original patentee, will all be, the subject matter of discussion when determining who is the owner of the final product. But purely answering your question, current regime, it is always going to be the the guy who wrote the algorithm. And if the law progresses to recognize other elements and other authors of the work which follow, then of course that is going to take its own course.
All right, in the paucity of time, I've been told that Mr. Anand was supposed to end the session, but due to some personal exigency, he is not able to be present for the seminar. So I would just like Director Sir to just end the session and give us the closing notes, please.
Thank you very much. And well, before I commence, let me put on record the words of appreciation for all the speakers, to begin with Mr. Shantanu. And it was like the opening batsman, I may say, the IPL time. IPL itself is a creation nobody thought of, because the kids had, rather I always say this, that IPL ever was envisaged by anybody, it was by the kids who used to turn any place to play cricket, and each one used to just join them and play around, and that was such a success story. But somebody developed it into a business model. But today's topic, and then of course Siddhant, and it was good to see the teamwork like Siddhant, and of course when I was seeing Ashish, like it was a very good combination as well. Like I'm just saying it as a learner of law. One is very straightforward, one is very happily taking it, other is taking time, and then coming to the topic. So one side, then other side, and then together is opening it very well. I really like that combination. And the best way that, when Shantanu, Mr. Shantanu, Ms. Jaya, they were explaining the topics. And as a result, as I always say that, each time you listen to one who knows it, you learn in a better way. And every time I attend all the sessions, so I was just taking my notes, I was making my notes as well. And you reminded me of a statement and which I read quite long ago, but I just remember it today. It all begins in your mind. What you give power to has power over you if you allow it. So when I see people talking about, will artificial intelligence take it over? Will we lose anything? Well, that statement has everything hidden in it. Like in Hindi, they always say, and this is something which I was just working upon. Allow me to say a few words in Hindi as well. They say, प्रतिभा और प्रतीक्षा अगर साथ हो तो आविष्कार बनता है. Means, when there is intelligence backed with patience. Well, you also have another word called saburi. But saburi, when you use it, it's Urdu. So, pratiksha. So, it's avishkar. और ये दोनों संग है तो आविष्कार है और दोनों में कुसंग है तो बोलते हैं अभिशाप है. And that's what we always have seen. Just to begin with Lotus 1 to 3. Nobody remembers Lotus 1 to 3. Everybody knows just Microsoft Office, but the one who created never got the credit. So for me, when it comes to my proprietary right, law becomes Abhishap. And the other who just takes away the credit cannot just say, I made it. Of course you cannot. And that was, I strongly feel that was the first time. Just look at Hotmail. It became the big word. Everybody was celebrating all across the world when the electronic media was not so active. But newspapers, everybody was talking about, not because the one who made it was an Indian, but Hotmail, I would be able to communicate. Napster came on the scene and everybody was just going gaga over. And then the Americans came with the legislations. We all know the DMCA and etc. And it has lost its space as well. And then there was another which was introduced by Yahoo, briefcase. People were saying, oh, fantastic, I can store my data. And look, iCloud. One began, others took it to the next level. So you go on developing. So idea expressions are different. But what is common is the curiosity. And this is what I always say, that curiosity is the coin, which has two sides. One is idea and other is expression. And how you use that coin makes the distinction between what is called as Avishkar and Abhishap. And when it comes to the present status, what you all discuss, when it is like, for example, we are talking about the commercial matters or the commercial codes and how IP would be handled there. You talked about software piracy. Nobody talks about it now. As far as my understanding goes, nobody's really bothered. Because we all have realized that there is nothing which will prohibit. Right? So greatly what we are doing. Are we saying that the law is, no, law cannot keep pace of the speed of mind. Sorry to say, but this is the reality. Law cannot. So we have to develop other mechanisms as well, like the educating people, bringing it to their notice, and accordingly they learn. In the context of artificial intelligence, I came across an interesting quote. Allow me to quote. This quote is by Alan Perlis. He says, in man-machine symbiosis, it is a man who must adjust. The machines can't. So we all have to come to this realization. Just look at us. We can't stay away from our mobile phone. And we say that artificial intelligence will take over. Come on, have we able to control our own feelings, emotions? We are talking about something which we say is emotionless, far better than us. Just makes the decision and just goes ahead. But when it comes to us, we are different to that. Just remember, was the apple, my Guruji gave this example, was the apple never falling? Why only Newton could see that the apple? Because he connected the dots. Otherwise it is there. So charitra or charitartha mein antar kya hai? That is the one thing. Charitra is the character. Charitrartha is how you make a livelihood. And just look at everybody. It was everybody's charitra that okay, apple fails, I'll eat it. Newton did not eat it. He rather he went for another statement, and everybody is celebrating Newton. Nobody is celebrating the one who ate the apple. So of course it was creative idea of what intellect. So that's why Pratibha and Pratiksha, these are the two things. And I was so happy to see, because the topic, the way you all dealt, it just made me, and I was just searching, researching, I was making my points, and thank you for making this day. There is one more I remember, which like the grandparents always make us this, they always tell us this story, but whether we understand, they always call us Mera Acha Bacha. They always tell us, Mera Acha Bacha. We never understand what that Acha Bacha is. But they always give us that feeling, there is Acha. You are very good. You are nice. You are like this. And accordingly, we become. So when something comes to us, should we become like that? And if we decide not to become like that, but remain what we are, then nothing like artificial intelligence or etc. can take over. So again, of course, if it can take, then that statement comes. Machine translation will displace only those humans who translate like machines. This is by A.R. Lomel, and he is so correct. He is so apt. So means we have to learn from this. Look, people, I always jokingly say that, whenever I'll make some statement, people may say that, I'm a nationalist and I'm this and etc. And I like that. That's okay with me. But like, for example, we are talking to each other. Just look at this, right? Nobody thought about it. But you find a reference in Mahabharata that there is a battle, and which one is explaining while sitting elsewhere to Dhritarashtra. Just look at the idea, but who conceptualized it? So that idea existed, but one conceptualized it. So the one who brought it into reality and for the use of others should be getting the benefit of it. So why not? Artificial intelligence, one creates it. Creator should get the advantage. But creator should share that advantage with others. Should he get or should she get something in return? Yes, they should be able to reap the benefits of their sweat, their blood, and the energy they have invested, not wasted. They should be given that. But at the same time, we cannot turn our eyes to probable situations. We don't call them as problems. We should call them as situations. And are the laws able to deal with that? Very simple thing, like people like to watch different serials, and I am also fond of. And well, when Siddhant talked about Terminator and etc., I have seen all those parts several times. I like Arnold Schwarzenegger in certain movies. I like rest of the things. I'm told he acts, but he never acts. He just says something, but with due respect. But if you see all those parts, what you come across is that, every time there is development and they're communicating some message to us that we are on this track. We took long time to understand that. Otherwise, that first movie was made long ago. And if you could see, but that was said long ago. And there are good serials, as you were talking about certain cases. There are 2 specific episodes of Good Wife, which are on the bot. And there is, like, I fondly watch, Good Wife as a serial because it's good about lawyers and then family drama, etc. I watch this with my, greatly with my daughter. She is fond of this. My son, he prefers technology, but he doesn't watch these programs with us. But in that, like, for example, they have created a bot who reads the statements on the blog and creates the statement. And there is such a wonderful argument. Does he become an employee? And if it is an employee, then there is employer-employee relation. How you cannot be liable? So such a logic and then reason. So we cannot say that master would not be vicariously liable. So because, it is subject to your direction and control. How can you say that it is a machine just did it? No, you feed it. So vicarious liability in the context of tort, you talk about law of crimes, even the criminal liability of the person, the corporation which is selling that product possibly may come. Australian law is very well developed. But you all made us think like this, This was not what I wanted to say, but when I learned to you, I must say what I am expressing is that expression I developed upon the ideas which you shared. Thank you very much. Your ideas were so wonderful. And it was very well moderated by you, Mr. Rohan, I must say, because it's not an easy topic. Artificial intelligence, people just feel that, it is artificial and intelligence, but people don't focus on, these are two words which make one term. Because end of the day, because it is mechanical. But yes, we also think mechanical. So we don't get the benefit of it. And it was so nice to hear you that yes, the best of the people. So I will just end up with one line. The message is loud and clear, which is there into open. Your mind is your greatest power. Use it well. So it is the user who decides whether it is use, misuse, or abuse. It is not the thing which comes before you. So thank you very much. And I would like to put on record the profuse thanks to Mr. Parveen Anand, because who always has been so gracious that ideas which come his way, and he always takes those, he collaborates, and it was he who gave permission for this collaboration. I would like to thank Mr. Ashutosh Upadhyay, whom I fondly call as Ashutosh. It troubled me a lot when he was a student. I can say this because, what can be a better forum, to talk about a student who troubled you most. But it troubled me in a very good manner because I learned a lot from them. And Ashutosh, thank you very much. It was you who were instrumental, who came with this idea. And people just went on joining us, and it went. Just look at this. Even on a Saturday from 4 onwards, we were having so many people attending it so interestingly, because the topics make the difference. The people who talk about it make the difference. So, and you made the difference. So Anand and Anand, all the partners, all the managing associates, all the senior associates, all the associates, everyone who is associated, the credit goes to you all. And it is so good to see that you are there to share what information you have and leave it to us to convert it into a knowledge, because we can just give information. It is the ability of one to convert it into a knowledge. So it was so fantastic. And I must say, today's session, I really enjoyed the most as well. I don't say that first was not good, second was not, third was not. Every session was a best session because you dealt with 4 different topics. And this is something on which not many discussions are happening when it comes to artificial intelligence and then piracy and etc. Just one line, because if you could focus on the international aspect, because AI cannot be dealt within borders. There it is something which is borderless. So we would require international effort, but that international effort should not be legal. It should be very mindful of the ones who develop, so that they understand the benefits and the possible losses. That is it. Sorry, I always take time because you can understand a teacher what to do.
Pleasure hearing you, sir.
Thank you very much. So thank you very much, everyone, and from the bottom of our heart. And yes, we would be happy if you could come visit the campus. So the students are not allowed to come, but and one message I always like to give, that our library is open to everyone. So people don't have resources, they can come, they can use our library always. So of course, the library of Anand and Anand, I have seen it. It is a fantastic library. We also have a good library, but at the same time, there are colleagues or students you come across who may not have. So please pass this word so that they can come, they can use the resources. We are always there. And this is a symbiotic effort. That's what Symbiosis believes in. One world, one family. And we are allowed to do this, and we always will do that. And thank you very much. And sorry for taking up much of your time.
Thank you so much, sir. Have a nice evening.
Thank
Thank you.
you. Thank you. And thank you. Please for ending.
Bye. Thank you, Rohan. Bye, everyone.